Good morning, everyone. Oh, gosh, that's loud. Sorry. First thing Monday morning. We're going to go ahead and start the subcommittee on 553. Thank you for the members for being here and for the members of our audience and being here. This is really to kind of wrap up where we were. We got in a lot of discussions this last time. We did get a letter from a physician, I believe, at Dartmouth, that really spoke more to the original bill, not the how it was supposed to be, that amended version. I have not seen any statistics that we were told or anything was going to come. Did anybody else get any statistics from anyone? No statistics, just opinions. Yep. And we do have, I'm going to give you all just like a couple minutes to look. So if you look in your emails, if you have it with you, but our committee researcher did look at other states that have the prenatal part of it in there and the substance abuse part of that in there. So we just have that. Can you get that on yours, Representative DeSimone, or do you need to borrow my computer? It came in from Kristen Grant. She should have just sent that this morning. Grant. And this is listing all of the
17 states
that states, yes, that do have it. Most of them are not as protective of mothers as what ours is. So, but you can go ahead and kind of look at those. I think that was one of the bigger parts of our discussion this last time.
that this is really a strong bipartisan bill. This bill originated from Senator Carson, who is, of course, the Senate president, that there's no Republican or Democrat. This is a bipartisan bill that was worked on for months, correct?
Really
And
years.
was
yeah.
it weekly that they worked on this last year?
Yes.
So and weekly for months. So it's not like this is just some fly-by-night legislation, that this has been worked on and is a bipartisan bill, spearheaded by Senator Carson. So I just wanted to get that out there so that people aren't thinking this is a Democrat bill or a Republican bill. This is a very responsible bipartisan bill to update the definitions in the Child Protection Act. Does nothing else.
No.
There's no criminal penalties anywhere, nothing. This is just updating the Child Protection Act to bring us in line really with a lot of other states that are out there. So I just wanted to address that.
Thank you. Yeah, I think it's important to note that this has not really been updated since 1980. Since then, we have had a plethora of knowledge and finding as to what abuse looks like, as to what toxic situations look like within families. And we also understand, and we have said multiple times in this legislature, that we do think that family is the best place. That's the best place for kids. So we want to be able to identify when there's an issue within a family so that we can have support for them so that they can, work on those things and have ways to come together as a healthy family. So certainly right now, the way that the definitions are, there's a lot of vagueness as far as when DCYF can step in with interventions, not to take the kids away, but just to provide support. Yeah, services and support. And so we're really at a situation where we have seen some extreme cases where when we're hearing about it, it's too late for the child. We certainly have had testimony of doctors from Dartmouth come in and talk about babies who have broken bones that are not able to move or anything, and then they go back to the parents because there's nothing in our provisions right now that would prevent that. As a matter of fact, the way that we have it now is stated that they do go back to their parents. Nobody can say anything. If there's no finding, which nobody's talking, then that's part of the problem. We also have a state where parents can decline to have DCYF come in. This does not change that either. So this simply says that we understand that the safety of children is important, and this is what we're outlining is we find abuse or neglect. We do have rebuttable presumptions of harm to make sure that we're mitigating and not over penalizing parents, but also I think it's important to have updated definitions because not only do we protect kids in this, we actually protect parents too. Mm-hmm. If we have a deeper understanding of what abuse is in a modern way, we're not penalizing parents that maybe that's not abuse. So do you have a question? Yeah.
I just want to point out, I'm just why I'm here, and I'm on House Criminal Justice and Public Safety, and we're considering a bill, HB 257, which greatly expands the criminalization of, let's call it inadequate parenting. It's a child neglect bill, and criminalizes neglectful parenting with some specifics. We're really struggling with the bill because I think many on the committee believe the DCYF system, the civil system, is better able to manage families that are having problems going forward than is the criminal system. There's a lot more limits, in the criminal system, and it may be that 257 doesn't need to go forward or needs to be significantly scaled back as the committee understands what's going on with 553. So that's why I'm here.
Thank you. I appreciate that.
Could we ask?
There's only like 800 bills this session. And I think that, you'll see within our committee, our regular committee and stuff, we have a lot of bills coming forth this year trying to kind of attack this problem that we see certainly with Harmony Montgomery and some of our other notable cases that we have seen the breakdown of the system. So we have a lot of different bills trying to really come at this issue of protecting kids. I think this is a foundational bill because this is what these other bills then get built off of. This is simply definitions. So that way, then we can basically not have a crumbling foundation as to how we're protecting kids. Right now, we have a very outdated and crumbling foundation, which is leading to a lot of bills that either can't be followed or that are just ineffective or maybe too punitive as well. So we need to make sure that we have this foundation in there. Have you guys gotten a chance to kind of look at that and see that there are a lot of other states that have that? Okay. Just to paraphrase, so last time we did talk about constitutionality of this bill. Representative DeSimone, it is one of her jobs to make sure that it is, constitutional as far as what we're doing. And so you did find it that is a constitutional bill, correct?
It is absolutely constitutional. I found, I think, three court cases that the Supreme Court found it constitutional. People need to remember when they talk about the constitutionality of bills is that unless it is specifically stated otherwise, bills are constitutional. This bill happens to be a bill where for many, many years, due to the amount of media that we have access to, actuality and perception are the biggest hurdles that we face. So the perception of what is and is not child abuse and neglect is not always actual. It is not always specific enough. So one of the issues that we face right now, or questions, is, so if I say to my child, that's it, go to your room and don't come out until your room is clean, that could be emotional abuse or neglect. I've checked with attorneys, with judges, with psychologists, with psychiatrists. Now, that's a situation where, on the face, absolutely not. If you say to your child, if I have to leave you in that room for a month, and you do, and you refuse to give the child food or access to bathroom facilities or water, now we're talking a different story. But actually saying, that's it, go to your room and don't come out until it's clean, or that's it, go to your room until you can change your attitude, things of that sort, that's not emotional abuse. It absolutely is not. So the fear factor that, and I'll go back to the media situation, the fear factor that the media ends up putting out there for people is the problem that we have with society's perception of what is and is not. One, the perception that it's unconstitutional is, in my opinion, not true. Two, the perception of what is and is not emotional abuse has already been talked about in 13 other states, and it has already been discussed in the courts in the past. All this bill is doing is putting a finite list of definitions. It is not saying that if you do this, you're going to have your children removed. First of all, another perception is that DCYF or DHHS can walk in your house and take your kids. That's illegal, to be honest with you. They still have to call the police department, and the police are who removed the children from the home and put the children someplace deemed safe until the investigation can be done. So that's another perception. It is not in this bill. It does not give any entity any more latitude than what the law already provides to keep children safe. The definitions are merely helping those entities parents and the courts understand the definition of all of these abusive behaviors so that you can't be brought into court and my child did it. So my child, who is now almost 50, when she was 12, decided that I was an abusive parent because I told her that she had to swish the toilet every day. And she called child abuse. And I gave her the number. It is a perception that, is that a gross, disgusting job? Absolutely. But is it child abuse? Absolutely not. So the perceptions are what we're trying to clean up and make finite in this bill. And that's what I hope people take away from this bill. If you look at the list of sponsors, it is typical of Children and Family Law Committee that it is not a Democrat bill. It is not a Republican bill. It is a good bipartisan effort to help the children and the families of this state. And that's why we're working together to get this done and get it done well. And that's my perception. Thank you.
Thank you. I appreciate that. I would like to, normally I'd say elephant, but I'll say gorilla in the room. I'd like to talk about the gorilla in the room. There has been question, what if I disagree with my child's religious choices? What if I disagree with their orientation? And that kind of stuff. Is that then, if I disagree with them, can they take my kids away? What if my kid tells me that they're trans and I say, no, I disagree with that? Is that in itself reason for them to have an intervention take away? No, not at all. I will be quite frank. My son, when I was getting threats from a particular group, that my son decided to say that that's the political leaning he was. It was a rough moment in time. That was last year. I was getting death threats. I was getting threats of getting feathered and tarred because I said not all parents are good parents. Not only am I going to stand by that, but I'm going to stand by my son who said that's his political leaning. And did we have a disagreement? Absolutely. I mean, did I say, how could you do this? And did I get upset? Yes. But the difference is I didn't take it to the point where now he trembles when he gets around me and he wants to talk about it, or he curls into a fetal position if somebody brings up this particular topic. There are levels. You are allowed to disagree with your kids. It's how you go about it that makes the difference, whether or not it's abuse. Our children need to understand that not everybody's going to always agree with them. That's okay. But they also need to understand that they are an individual who has rights, who has entitled to their own opinions, and can make a disagreement with somebody else. That's what we're raising them for. We're raising them to go out and think critically in the world. So I think that's very important to acknowledge too, because I do understand that people have that fear right now. And as my grandma used to say, I don't want them to borrow trouble. Don't have a fear that you don't have to have. It's just not a reality that we're looking at with these definitions. So, Jody, do you have any, Representative Nelson, do you have any input?
Hi, yeah, thank you. Thank you, Madam Chairwoman. Just further to that, there are clear definitions of what emotional abuse is. I think that Representative DeSimone had brought up the last time that there in law already in New Hampshire, the other types of abuse are defined. So I think it'd be very helpful to have that definition as well with, what the definition of emotional abuse is. I have done a lot of research, and most states now do include some definition of emotional, mental, psychological, abuse in their child abuse laws. Also, too, I'm going to be quite frank with everybody. I was involved in a emotionally and physically abusive relationship when I was a young adult. And I think a lot of us who have can understand the statement that I'm going to say. I did have, and in the times of when I was berated for hours, I had said, hit me because it would hurt less. As an adult, I would say that. A child can't say that. And I know because I've spoken with people, and particularly men, who speak about their severe emotional neglect and abuse. You can see that hurt child in their eyes, no matter if they're 30 or 80. So I really, I hear some of the concerns. I'm not just discounting anybody's concerns. What I am saying is that if we're not going to include emotional abuse in the definition of child abuse in New Hampshire, we are worrying about what is conjecture to the result of children here in New Hampshire and families not getting the help that they need and deserve. That's it.
I'm good. I concur.
Thank you.
I couldn't have said it better.
Thank you.
That's very good. Go ahead.
Do you have a proposed amendment or what?
Well, one thing that we talked about, so I don't know if anybody else had a proposed amendment, but one thing that we did talk about and that has also come up is that trauma-informed language around substance abuse disorder. We have that as another concern that we have heard about. I've spent our week off doing a lot of research, looking at that substance abuse disorder, because I also heard that currently, we had people, based on what we have right now, we have people afraid to go seek medical care if they have substance abuse disorder and are pregnant. And so they're already afraid. So then it's looking, well, how can we make this better? So one thing that I do like about the language that Senator Carson worked on is that we do talk about, and first of all, this is not in the original bill. This is the amendment, because the original bill, when it went to OLS, got reevaluated. I don't know how to say that, but it was not what we wanted. So what we actually wanted is the amendment that we have, and that talks about the rebuttable presumption of harm. It also talks not about when the baby is in utero, because that does not fall under the child protection statute until the baby is born. But we do want to acknowledge that harm can come if a child is substance exposed, but that can't be the only thing that counts as neglect, because we also understand that there are a lot of parents, when they find out they're pregnant, they decide, that's it. They want to end that and stuff. So they are struggling with trying to get to that next step. I think it's important that we have in here that if they are monitored by a licensed healthcare provider, which, by the way, there is not a timeline on that. It doesn't say the whole 9 months. It doesn't say, it just says that. And I think that's an important, when this bill goes through, I think that would be an important thing for people to note, to hopefully help them to want to get medical care and get that provider involved. Because if a provider is monitoring them, then that falls under the exemption here, that we understand that there are a lot of nuances to substance abuse disorder, and that we understand that people are trying to get help and should not be penalized. They should not be unfairly looked at. Right now, it is my understanding that because we do not have anything in there, and because we are all mandated reporters, if someone would come and say have a baby that's been substance exposed, it is an automatic screen in, because there is not any kind of exception right now. So if that gets called in, which there's nothing telling the doctors not to at this point, because in law, because we're all mandated reporters. So I think that's important to note as well. And trying to do, once again, right by the children. We do understand the complications that children have. So we do have more trauma-informed language for that particular section that we discussed. Did anybody else have anything for an amendment on any of this? The definition.
we need to add, as Representative Nelson said, I think we need to add the specific definition for emotional abuse. I don't think what we have is specific enough to properly cover it.
Okay. I'd like to call I know Office of Child Advocate is here, and I'd like to call them up about that definition. Why it's not in there? Can we get a definition in there? What? And then DCYF too. I don't know. We don't have 4 chairs, but you guys would be good to include in this as well. You're fine. Sorry to call you up. It's like you don't want the teacher to call on you. I apologize.
So I know we talked about defining emotional abuse during 8 weeks of weekly 2 to 3 hour long sessions with Senator Carson. And, you know, Senator Gannon was also, Representative McMahon was also there. We, in looking at all the other states, rather than defining emotional abuse or emotional neglect, it was more the way it currently is, that abuse or neglect was being defined as the mental, emotional, psychological. So through all those conversations, and maybe Susan or Jen remember more distinctly, we ended up going kind of back and forth, but not putting in a specific definition of emotional abuse or neglect, because, you know, we also didn't define mental abuse or neglect, or, you know, psychological abuse or neglect. That sort of list of words is what the abuse or neglect is. So I think the decision had been made, rather than get into the weeds in defining every single one of those. But we could certainly talk about it. Where we did focus was the definition of psychological maltreatment, which again is actually coming back to more of the examples like Representative DeSimone just gave about the belittling. So I think that's how we kind of ended up resolving that issue, that most of the concerns and examples we were hearing actually were defined in that psychological maltreatment, which was already a definition in there. That's not new, but the language became a lot clearer, like what you're saying, of sort of those specific examples. And that was language we pulled from a couple of other states. It had actually been a longer list during those many, many hours of committee hearings in the fall. We deleted one that we were afraid may go too far. So it was really an evolution of that language. And rather than define the sort of emotional piece, we focused on that psychological maltreatment, which is at the bottom of page 6 of the original bill, 25A, if I can read Roman numerals, which is possible if not. So that was really where we'd focus that piece, because that is where sort of the demeaning, threatening, humiliating, which seems to be the examples everyone gives when they're thinking emotional, it's really psychological. So that is sort of how we landed with that other committee after a lot of conversations. And then within serious impairment, emotional was already in serious impairment. So that's the middle of page 7. Serious impairment is another place where we really were striving to be a little bit more exact, because if you look at the definition of neglect, it's the enumerated plus serious impairment or likely to cause serious impairment. So it's not just the definition of neglect, it goes hand in hand with serious impairment. So serious impairment was another piece. And that was where we'd seen a lot of gaps in cases that had come to the OCA's attention, either the division or the courts sort of trying to get into the nuance and nitty gritty of what was serious impairment. In some cases, including those severely injured infants, that we were seeing gaps where, the division might think we have a solid case, and a court or somewhere else saying, man, you don't quite meet serious impairment. So those were the two places we tried to focus on to build out the nuance and clarity. rather than try and define emotional abuse or neglect, because then you're starting to like, do you define mental abuse? Do you, it got a little bit too detailed, but we did definitely talk about that a lot and go back and forth on it a lot. So hopefully looking at serious impairment together with neglect, and then that psychological maltreatment, which is really underutilized currently. I was a former DCYF attorney, and there were lots of cases that we felt did rise to the level of psychological maltreatment, sort of what you're talking about, Representative Nelson, of just the berating that's almost worse than the physical we would see in cases. And psychological maltreatment was very rarely used because it was just really hard to prove. So that was a gap we had seen and in cases. But certainly if
On the emotional
we have
abuse as well.
ideas.
If I can add, in looking at different emotional abuse definitions across the country in different states, there was a lot of bringing it back to emotional injury, and it was talking about an injury as an incident, a defined event, and in really digging deeper into that, we found that could actually reduce the amount of supported allegations or calls to the agency if you have it so strictly defined, because it's hard to then define that injury. And there was a lot of conversation in the committee as well about, well, would that have to be something that a doctor then diagnoses that an injury actually occurred, a therapist or a counselor as opposed to a medical doctor. And a lot of questions around, is that going to hold up if we're looking for a specific injury versus spreading it in these other areas to catch more of it?
Because that would be a high cost to the state if you're having to hire experts for every single case. So, there's a Supreme Court case of, it's around pornography, but you know it when you see it. It's real hard to define, but in sort of the totality of the circumstances. So that's why we try to put that clarifying language in places without raising the bar so high that now, and we'd had a case where a child had been physically assaulted by a caregiver, received a black eye, and a court had said, oh, that's not serious impairment because the black eye heals. But being physically assaulted to that extent by your primary caregiver is a different type of injury that is difficult to define, because the fear, like you were talking about, Representative Gregg, of you can have a disagreement. It's when your kid flinches every time you walk into the room, but that's very hard to define. So that probably wasn't super.
Hello. Thank you for your answer. I also I have a Representative Rice gave me a nickname. I'm the late night researcher because if I can't sleep, I'm researching and sending her stuff. And I think that feedback that I've just gotten from other legislators and concerned constituents is that in our law and our RSAs now, like literally it was like physical abuse is blah, right? So I definitely see what you're saying, but I think it's hard for people to kind of get around that it's not a specific, definition to refer to, like some other types of abuse in RSA. And I know also in other states, like for example, well, never mind, because I just clicked out of it. I don't want to waste our time, but there are other definitions that are, I'm sorry, if you could just please hold on one second. I think it is here. Otherwise, I can return to it later. It was more, less what you were talking about and more of defining it as something that is habitual, and being vague like that, resulting in something. That's all.
And I think that is sort of the language that ended up in psychological maltreatment, is that it did require a pattern of threatening, demeaning, humiliated, which may include but not be limited to, and then gave very specific examples. And I think this language came directly from Colorado, maybe, or maybe in Connecticut, some examples. Yeah. So, and again, so that's in psychological maltreatment. but maybe that's a definition of emotional abuse. I mean, I guess, the words, but it's talking about belittling, terrorizing, threatening abandonment or harm, exposure to criminal activities. It is sort of a laundry list.
Can I just do a follow-up? I'm just trying to get this bill passed.
Yeah,
And there are a lot of legislators that have a problem that we don't have some sort of definition. So do we combine those two together? And,
Maybe.
that maybe is something that we should work on.
Okay, so in research, types of emotional child abuse: rejection, ignoring, shaming or humiliating, terrorizing, and isolating, and gaslighting. So why can't we, why can't we just put that in there? Rejection, telling a child they are worthless, unwanted, or unloved.
So it looks-
Ignoring, failing to respond to a child's emotional needs or withholding affection. Shaming or humiliating, constantly criticizing, belittling, or making a child feel ashamed. Terrorizing, using threats, yelling, or intimidating behavior to control a child. Isolating, keeping a child away from friends, family, or social interactions.
I'm sorry, I was not. The bottom of page 2, under the definition of abuse, and it's hard to read because all the crossouts, but we did define emotional harm under abuse and includes that psychological, see, I knew psychological maltreatment was.
References it.
Reference. So that was how we built it in. So emotional harm is defined under abuse, paragraph B. And it incorporates that psychological maltreatment that I was reading, which is similar language, but I like that language you were reading, Representative Rice, too. So certainly there could be tweaks to it, but we did try and define emotional harm. It's there.
Yeah, we have. So I have something actually just forward to you that has it defines each, like, for what verbal abuse is, constant criticism, or each of the 7 parts that they have defined officially as emotional abuse. And I'll forward that to all of you as well. Maybe that's something that if you really feel strongly that we need to be more specific with this, because certainly if this is going to upend a very important bill, I can't stress enough how important this is. We've been trying to get this updated for ages. So if this is something, yeah, go ahead.
Hi, Annette. I'm sorry, I don't know why I said hi. Thank you for taking. Hi. Oh gosh. It's I'm trying to streamline my thought here. We are having a lot of issues with family court and parents not understanding certain parts of law regarding to family court. And I think that by being vague in describing this kind of thing, honestly doesn't give a fair shake to the parents. They might not understand specifically what they've done wrong by law, and to have it be determined by somebody they might feel is being subjective. I don't know if that's good.
Go ahead.
I'm agreeing with that 100%. Saving a few keystrokes is not going to save a child. I remember a person that used to come to our committee. Representative Rice will remember him. The poor man had just absolutely no idea that what he had done was wrong. It was a horrible thing to his child when he thought nothing about going up to her with his hands, touching her and saying, "Oh, you're almost as big as your mother." He meant in his mind nothing bad about that. He had no idea how inappropriate that was. He had absolutely no idea. And that, and many other reasons, his children were removed from his home. And he used to come to our committee and say, they took my kids for no reason. I asked him to bring his transcripts of the trial. He and I sat for an hour and a half going over them. And I pointed out to him at that point how inappropriate the behavior was. And he said, oh, now how come it doesn't say that in the law? That's the point of these definitions. This particular person, may God rest his soul, had no idea that what he was doing was wrong. He had no idea the effect that it had on his children. None. And that's what we're hearing a lot of, is that they just don't get it. In this bill, if this does not pass, and it is not specific, like Representative Nelson said, then we have not done our job.
I agree. And I think that's really common for people who are probably caught up in cycles, passed down from generations of what they think is appropriate. They don't have that insight into their own behavior. And of course, we have mental health issues and other things. So there are some hiccups in our system for sure. Yes. Do you have a comment?
Just speaking as a lawyer who, for my whole career works with language and what covers things from the point of view of prosecuting cases or getting DCYF involved, and the better, and giving notice. I'm supportive of the idea of having a list, but I'm also supportive of changing the language that you see all the time in the law, which may include but is not limited to, that kind of, we don't want the list to be exclusive. I think instead of having which may include but is not limited to language, you need a sub paragraph that says some version of, and I can, later today I can write it up if it's valuable to anyone, some version of the examples given in this statute are just examples. It's not an exclusive list, and there may well be other behavior that it falls within this. I think that kind of notice to parents would be more explicit than the language everybody ignores, including but not limited to.
It would be. I think that we run the risk when we start giving examples is that there's no way we can list the millions of examples
That's the
that we
problem
have.
with the list.
So I think I understand and I hear the need for a specific definition. For those of you that at DCYF and Office of the Child Advocate, I've sent you maybe something, and all of you, something that we can kind of start from and say, could this work? This is the standard definitions of what emotional abuse looks like. I certainly don't want to upend anything in here, but I do see the need that I think we're going to have another subcommittee meeting, to be honest, unless, are you,
Yeah.
are we?
Yeah. So.
So we'll need an
I sent
amendment.
you?
Did you just send it?
I sent, yeah, and that's what Representative DeSimone thinks should go in. And then we could include the language of may include but not limited to.
Again, I would recommend a better language than that. Instead of having the language may include but is not limited to, I would say, for example, and then have the list, and then at the end of the list say these are only examples.
Well, we can have a motion to have an amendment, but not have the full amendment language right now. So,
So I move that we have an amendment.
okay,
If I may add
second. Okay.
a bit of context as well. I just want to share from the prior committee work, we did have a longer list that went under here. I believe it may have been the 7 that you had that you have shared with us. And it was parsed down a bit because there were a lot of questions about some of the belittling aspects and really wanting to ensure that it stays at that real high level that's fitting abuse and not those parents that are, just threatening their child that you're going to be in trouble if type of situation. So this list under psychological maltreatment is parsed down after those many committee meetings in the fall. So I just wanted to make sure that as we look at it again, we may have to have some further conversations, or we may be able to share some context with you all about which ones we were asked to parse down by that committee already.
And I can also, the including but not limited to language, and again, we had all talked about that. In criminal law, I know it's much less common. It's got to be very exact and clear for criminal penalties. But, with child welfare and social work, while we want it to be clear and transparent for parents to know, I think there is a certain amount of, once you start listing things, anything not on that list is fine. And if you start listing every single thing, it does become, it's going to be a 300-page long statute. So a lot of the conversations we had in the fall also with Senator Carson in that subcommittee was building that trust in the child welfare system, that these are trained social workers going into a home and you never know what you're going to find. And the thing that got called in might not be the worst thing you find when you set foot in that home. And so there was conversations with various players of how, because this whole statute is about protecting children and being able to have that little bit of leeway. So it really was sort of trying to find that gray area of that the statute is clear to make sure you're not getting called in for sending your kid to their room or clean their room, but also allowing the child protection workers who are the trusted professionals in this field, the latitude to protect children. And some of those gaps we found were places where the division already felt that they knew that this was abuse or neglect, but that the law was not sort of allowing them to offer services. So clarity is great, especially as an attorney. We like things to say exactly what we mean for them to say, but we also do want to find that line to allow, when you walk into a situation, some latitude to be able to protect the children in that home, because it could be something completely unrelated going on.
So would you speak a little bit about if the verbiage was in there that said shall be included but not limited to?
And that's the verbiage that is currently used in the current statute and in many other states. And I'd be interested if Representative Nelson, what you found on your exhaustive review of states. It's hard to make a law that you want to allow some wiggle room to protect children, but you want to be clear without using that language. And I think what Cassandra was just saying is we really parsed out, it's in the psychological maltreatment section, but we could certainly move it to make it clearer. That was sort of a laundry list with specific examples. And, it included trafficking, and there was a lot of language in there. And Senator Carson in her committee did parse some of it out as kind of addressing some of the fears that were being felt. But I mean, I guess language that these are just examples, but that's no clearer. If you're just saying, here's a bunch of examples, but those aren't all of them. It's really just the same way to say, including but not limited to. So I'd be open to if you have other language or whatever that, but that is the problem you're trying to address.
The for example, the only reason I brought up the for example language is I certainly as a lawyer, they as lawyers, all of you who've worked on drafting and legislation like this, we all understand what including but not limited to means. I think that language just goes right by people's head who are reading it. So the for example language, the parents who are subject to this understand that it's just a language thing, but I think it's an important one, the for example language.
What
I believe it was EG to begin with. I don't know if what you read, it had an EG which is
EG is even worse.
well, right, and so we took
So I just need to remind everyone that everything has to go through the chair. Okay, that is out of respect for her. So these conversations, you can't just speak up like that. She is the chairwoman. Okay, thank you.
Thank you. I think, the more that I hear, and I did pour over the Senator Carson's work, their committee, and certainly this was a lot of hours. Representative McMahon is on our committee. He worked very hard on that. I think what happens is, and this is pretty typical in today's society, is that our first shot at this came out. OLS did not give us back what we gave them. And, that led to some misconceptions, certainly out in the public. And then that little snowflake, it turns into a snowball, and then we continue on. So a lot of this is having these conversations to help people understand what this is and what this is not. This is not in any way punitive. This is not in any way, the final say on now you get your kids taken away or anything else. And we've already discussed this, but I don't think it can be said enough. So I understand with specific language, and I did read in their report why they did not get so specific with some of that, because part of this is in the training. These are bills that we also have. What does training look like? What does, gosh, what I can't think of it right now. What DCYF is able to do, what the Office of the Child Advocate, what they're directed to do. All of these things fall in line. This is not, while this is a foundation, this is not the end all on what we're going to do with it. Certainly things come after that. So I do want to be super mindful, because I do know that they talked about why they didn't have things listed. And it really is because of, because they did have that in there first. I think actually Representative McMahon was one that, was talking about that pretty specifically, and also came to the realization that when they started doing that, there was an issue. So I think that we could look at if there's something more specific, or putting it in a different area, what is already defined. That's the other thing too. When we look at this bill, I think sometimes people see one section of it, and you really have to read it in its entirety. And I know that you all have. I know that you've done your due diligence on that, and I appreciate all of your work on that. And that's part of our issue right now. But certainly if we, can maybe outline it in another section as well, that would be good. But I do think we have agreement that we need an amendment. Certainly we want to have more trauma-informed language. That's we want to be sensitive to that. And I think that we could look at the definitions with Office of Child Advocate this week. If Representative DeSimone and Nelson, if you wanted to talk to them, and then you could put forth the amendment if you'd like, if you come up with one. I know that we're all hearing from a lot of different sources, and we're getting a lot of different emails, and a lot of the fears that we're hearing are unfounded. I will say that they are just, misconceptions about what we have here. So, it's hard to put it all, it's that toothpaste. It's hard to put it all back in the tube once it's out, but we're trying to figure out how to mitigate this for people, because I don't want people to be afraid they're going to lose their kids. We have a lot of really great parents in the Granite State, and we have a lot of parents who want to be great parents, but they just need the help to become great parents. And so I want to make sure that we're including all of them. Did you have something?
And I would just like to reiterate that this is about intervention, right? They're not coming in to take your children. If they see that you need help or guidance in an area, they can provide those services to you, but they're not coming in to rip your children out. These are the days of the old system. We have done so much work over the years to keep families together, because we know that that's what's best for those kids. Even the most abused child will want to stay with their parent, and sometimes it can do more harm to pull them out of that home than to keep them in it. So these are things that we have to remember. There were the old days, these are the new days, where we are focusing on keeping families together. I cannot express that enough. Thank you.
I echo those sentiments exactly. the good news slash bad news is that people are really being focused on that one section. And I say good news, bad news. The bad news is people don't have a conception as to actually what emotional abuse is. And the reason for that is because most people don't see it. They don't see the result in the child. You cannot always see a broken heart. The good news is that we do have specific criteria that we can amend the bill to speak to. We as a society, many of us are coming out of a generation where all of this abuse was so prevalent. We didn't even know we were being abused. So how many of you here, well, I turned out all right. Maybe not. Maybe not so much.
I was a hot mess before therapy.
Bingo. As was I. As was I. So if we can pass this bill, and it's the same as what we're dealing with right now with kids who are involved in a multitude of issues like drug addiction and violence and being thieves and whatnot. When we started having agencies that would put kids through challenge programs and so forth and so on, we started teaching the children in a nice way, an easy to understand way, their behavior was wrong. And now the state's focus is more on intervention. So if we have this bill that passes, that gives the specific definition, zero consequences in this bill, because the consequences, if you break the law, are already there. But understanding that this is all for intervention, it is, then we go to the prevention. And that's what this is about. So I agree with you there. And I think that a small amendment to the bill to just define the emotional abuse aspect, but not limited to, will bring us right into this century. And it's going to help the kids stay with their parents, and it's going to help parents be able to love and adore their children more.
So thank you. And I think that we will be talking to you. So we already have a motion and a second to have an amendment. Before we can close though, so we do understand that we're going to be working on this and have that before we have the exec session on it. It's a Monday. Got a lot going through my head. We do need a motion on how we feel about this bill, whether our recommendation will be OTP, OTPA. So we'll have to have a motion and a second and a vote on that.
OTPA.
Okay. OTPA. Second. Okay. All in favor? Aye. All opposed? Okay. So that will be our recommendation. Thank you all. This has been hundreds of hours I think we're over 100 people now, and we are really trying to get it right for the kids. So, and that's really the basis of our committee, is to get it right for the kids and make sure that we are doing our best for them. And I thank you all, and we will see you soon. I think that concludes the session. We will do one with everything on it. Yep. subcommittee is